Good afternoon, everyone. Thank you for joining us today. We have myself, Mirta Fadul, and my co-partner, Michelle Canero, founder of our Canero, Lammers, Fadul, and Acevedo law firm. And we're going to just walk you through a few options that if you're a foreign individual that wants to move to the United States and pretty much wants to run their own business, what options do you have to migrate to the United States?
Just to thank, I'd really like to thank Patrick for joining us today. Patrick and Visa Franchise have been a tremendous asset to our clients in terms of guiding them and directing them on potential foreign and U.S. investments. It's a very difficult landscape for us as immigration lawyers, where we can't give any advice on business investments. But I found that his company has done a really good job of doing the due diligence and presenting clients with options. So we wanted to have him here with us as we talk about those options, because we usually turn to experts such as himself to guide our clients on what the potential investments they can do are. And it's hard to find people that you can trust, because there are a lot of predatory brokers out there who are trying to sell something because it benefits them on commission. And that's been the complete opposite of the kind of due diligence that Patrick and his company have done. And that's why they've made themselves a name for themselves as one of the premier sources for due diligence on franchises nationwide, not just for immigrants. So thank you for being with us today, Patrick.
No, thanks, Michelle, and look forward to your presentation and then presenting a few of the different franchise opportunities and providing some free tools as well as paid options for those seeking a franchise for their investor visa.
Mirta and I, along with our partners, Karina and Carla Lammers and Acevedo, we founded the firm last year. We've been in practice jointly and separately in Carla and Karina in a different firm. But with the merger of our two practices last year, we now have a full service immigration firm that offers not only business and investment services, but also we now have a humanitarian removal and family department, allowing us to really assist our clients in all aspects rather than having to refer things. We can handle all issues our clients face in-house. So that's been a tremendous benefit this last year. And Mirta runs and leads our non-immigrant visa department, and has been the brainchild of our EB2 national interest waiver and EB1 extraordinary ability practice. So I've asked her to present to you today on what some of the non-immigrant visa options are that you can consider as an entrepreneur who is considering investing in a business in the United States.
Thank you so much, Michelle, for your introduction. So as Michelle said, I'm going to start by covering some of the non-immigrant visa options that our entrepreneurs have to come to the United States and basically be able to run their own businesses here in the United States. Non-immigrant visas, just to remind everyone, are the visas that have a time limit, and some of them can be renewed for a specific period of time, but they would not ever take you to a green card. Okay, this is just temporary basis visas that will allow you to start your business and establish yourself in the U.S. while you also explore some permanent options that Michelle will cover in the next presentation. I mean, after myself, I'm sorry. I'm going to start covering the E1s and the E2s. The E1s and the E2s are one of the most popular visas because are based on investment. The client and the potential entrepreneur needs to have the qualifying nationality, which is established by the Treaty of Commerce between the United States and that specific country. For example, we have countries such as Argentina, Spain. The clients that have that nationality can opt to either explore the E1 or the E2. The E1 is based on trade, specifically trade between, let's say, that qualifying country, let's say Argentina, in the United States. The E2 is it's based more on the investment that that entrepreneur makes in a U.S. company, and that will qualify that person to apply for the E2. The E2 and the E1 are great visas for nationals that do qualify, because it would allow the entrepreneur to start their own company here in the US, invest in the company, or bring inventory or trade from their own country to the United States and start their operations here in the US. These two visas are very important. Depending, the majority of the countries allow for a 5-year limitation on them, but they can be renewed indefinitely as long as the business continues to operate. This is a great option for foreign nationals to, start their operations and then explore other options of how to establish themselves in the U.S. And this is why the E2s and the E1s are one of the main reasons why we have our guest speaker here, Patrick, because he is going to explain a little bit later what options we have in terms of investing on a business here in the US. We also have the E3. This one is very particular because it only applies for Australian nationals. It's based on a job offer that the foreign national has on a US company. This one would allow minority shareholders of a company in the US to obtain through their own company a job offer in the United States to come and join that company here in the United States to operate the business. Very important. The person needs to be either a majority shareholder and cannot have the controlling interest in that company, because the idea is that the US corporation is the person that controls the employment relationship for that person, but you can have an interest in the company. This one, the E3, would also require the foreign national to have, let's say, a bachelor's degree or a master's or higher, or the equivalent in based on experience to be able to qualify for the E3. And again, it's only for Australian nationals. We have also the O1, which is a pretty flexible visa. It's the visa that is for extraordinary abilities. It's all often called a talent visa, but it's not only for the arts. We also have talent based on business, sports, and education and science. Okay, so if we have any foreign nationals in the audience that have achieved a level of recognition in their home country, let's say in the arts, or science, sports, or business, this is also one of the options that our entrepreneurs have to migrate to the United States. Very important for the O1s as well. The foreign national can have an interest in the US company as far as they don't have the controlling interest, because the idea is that the US company, it will be the person, not the person, but the entity controlling the employment relationship. We have several ways to how can we prove the talent for that individual, but it's mainly showing that that person has achieved a level of recognition in their home country. So this is another option. And the O1, very important, is also a visa that initially can be granted for 3 years. It can be renewed indefinitely. However, we always have to show that there's a reason to renew. Basically, what will be the purpose to renew in the United States? Very important, which I haven't covered, but for the E1s, the E2s, the dependents of those visas can actually work in the United States, which is a major plus that we don't have in the majority of the visas. For the O1, unfortunately, the dependents are not able to work. They're only able to accompany their spouses or parents in the United States. And also,
the L also allows for spouses to obtain work authorization. The nice thing about the L and the E is that work authorization for the spouses is incident to status, which is great because it means that they can immediately start working just with their I-94, and that document is I-9 compliant. I-9 is the requirement that companies need to undergo to verify that their employees can legally work. Now, the bad thing is both with the E's and the L's, the children are not eligible for the work authorization, which means that they also can't get the Social Security number. I know that that's been a problem, and it might be a bigger problem now that in Florida that the DMV is requiring a Social Security number to issue driver's licenses. So we'll be providing updates on that. I'm sure that's going to be an issue of litigation, but I think it's something we need to be mindful of, that there are tremendous benefits that come with the work authorizations for ENL spouses, but it does fall short of addressing all the issues.
Well, thank you, Michelle, for adding that. It's very important. Just as Michelle was pointing out, the employment authorization for the spouses, basically they can work anywhere they want. Very important to mention that for the O1s, the E3s, the E1s, and the E2s, the foreign national that is the principal of that visa is only going to be able to work for the specific company that is the sponsor for the visa. Okay, that's very important to note as well. As Michelle was commenting on the L1s and the L2s, the L1 is basically, it's a great visa for our foreign entrepreneurs that actually have a foreign entity, let's say where they have a holding company, or they have their subsidiaries or affiliate that are already established in, let's say, Argentina, and they want to open a subsidiary or an affiliate here in the United States, and they want to be able to transfer either their personnel or themselves to come and open the operations of the corporation or continue the operations here in the United States. That visa would allow executive supervisors managers, or specialized knowledge employees to be able to be transferred to a U.S. company and work in the U.S. entity or affiliate. Very important to be able to qualify the entrepreneur or the foreign national needs to be able to prove that they have been working in the foreign company for a consecutive year in the last 3, meaning that we have to prove that a person has been actually employed in the foreign company to be able to be transferred to the U.S. entity. L1 is a great visa because it allows for, as I said, the entrepreneurs and the employees to be transferred, and is a visa that unfortunately is only capped for a 7-year duration. And it's usually granted for 1 year, 3, and then 3. Unfortunately, it cannot be renewed beyond the 7 years, but it would allow the foreign national or the foreign entrepreneur to be able to pursue a temporary, a more permanent solution in the United States. We also have the Mexican and Canadian citizens, which have the benefit of applying for the TN visa. The TN visa is very specific because it's basically part of the North America Free Trade Agreement, and basically it's designed for professionals who fit below basically the specific professions, but it also allows entrepreneurs to serve as consultants in the United States. This is a great opportunity when we have foreign nationals that have different clients in the United States and they just want to relocate themselves here to be able to service their clients here in the United States. They can come as consultants under the management consulting figure, but they do have to serve as consultants. They cannot be just employed by a company here in the United States unless that company is actually a management consulting company. But the TN is a great visa if we have foreign nationals that are Mexican and Canadians, and is a pretty flexible visa in that regard. The TN, unfortunately, the dependents of the TN are not allowed to work, but they are allowed to accompany their principal, spouse, and parents while they're here in the United States. Very important also to mention in terms of children's, they are also they're going to be able to benefit from any of this type of visas, either the E, the L2, the TNs, as long as they're under 21 years old. The moment they turn 21, very important, please reach out to your attorneys because we need to find a solution for the children because they're not going to be protected under the visa that they come in. We also have the H-1B and the H-1B1. These are great type of visas. I'm going to cover first the H-1B. The H-1B is based on a lottery that opens every year, roughly March, April of every year. It's a visa that is strictly designed for it can be a foreign national or an entrepreneur as long as that entrepreneur doesn't have the controlling interest in a U.S. company, but it's a professional, which means that that person has either a bachelor's degree, a master's, or a higher degree, or has the equivalent to that bachelor's degree, which is usually 12 years of experience. The H-1B, as I said, is a lottery visa, so the biggest hurdle is to be selected in the lottery. Once you're selected, you are able to prove that you qualify for the visa and you're able to start on October 1st. The H-1B1, it's a professional visa similar to the H-1B. The beauty about the H-1B1, nationals of Chile and Singapore don't need to compete in the lottery to be able to obtain the H-1B1. They can basically apply directly at the consulate at any time of the year that they wish, as long as they qualify based on the nationality and the profession requirements. The H-1B is usually capped at 6 years of validity. Unfortunately, it can only be renewed in very limited circumstances, but it's a great visa as it allows their clients to also pursue, just like DL and the other visas, a way to stay more permanently in the United States. And unfortunately, H-1B1s and H-1B are not, the dependents of this visa, meaning the spouses, are not able to work under the H-1B. Perfect. I think that concludes my overview of the non-immigrant visas. Obviously, this is intended just to be informational, but I'm going to leave the floor now to Michelle Canero so she can explore with you green card options.
The initial idea with presenting the non-immigrant visas is that oftentimes we find that the non-immigrant visa is a much shorter path to relocation in the United States. It's still time consuming and the consulates are still backed up in issuing these visas, but it's nowhere near what we see as the delays on the immigrant visas. So in today's climate, we are finding ourselves having to pursue the non-immigrant visa as the first step, almost the bridge to get to the United States, and then doing the immigrant visa. So since we've explained the non-immigrant visa options are temporary, they have obviously restrictions and criteria that one has to meet, and they don't give you the full flexibility to work wherever you want. Most people choose to, once they've been here a certain amount of time, pursue the immigrant visa, which is the green card option. And lawful permanent residents would allow these individuals, if they qualify in the categories. There's family-based categories, there's the diversity visa lottery, and we're going to focus on the employment-based categories because the focus of our panel today is to give you ideas how you as entrepreneurs and self-starters and business owners can migrate to the United States. So now that we've touched on the different options of non-immigrant visas that you may be able to benefit from by investing and opening a business in the United States, let's talk about the green card options. So there are 5 categories of employment-based green card options. These are called EBs. The family ones are called FBs. And this has nothing to do with the alphabets of non-immigrant visas. Sometimes people confuse EBs with E2s. The non-immigrant visas are all A to, I think it goes to W, or V, it goes to V. And then the immigrant visas are EB, FB, and then the special visas like the lottery. So EB1, that's our first preference category. The government issues 40,000 of these green cards a year. And there are essentially 3 different types of EB1s. There's the EB1A, which is for extraordinary ability individuals. The benefit of this application is that you can self-petition, right? So you don't need a company to sponsor you. This category is exempt from the labor certification requirement. So there are categories of employment-based visas that require you to first get the Department of Labor's approval through a labor certification process before you apply for the green card. The EB1A for extraordinary ability does not. Now, extraordinary ability can be applied in the arts as well as in business and the science. There are a list of criteria. You have to be able to document your accomplishments in the field and recognition at the top of your field in at least 3 of those categories. But the categories and proving evidence in those categories isn't enough. They also look at the totality of the circumstances, what they call the Kazarian standard, to ensure that you truly are at the top of your field and that you are coming to the US to pursue the area and work in which you are recognized as having extraordinary ability. So this gets a little difficult where people have maybe recognition in awards in one field, press in another, maybe they've had a leading role. It all has to be a consistent theme and all has to be focused on the same area of work. And we always have to show, even though it doesn't have to be employer sponsored, I always have to show that you're going to continue in your work. That makes it a little bit of a difficult case if, for example, someone hasn't been working in their field for a decade or more. This happens a lot with professional athletes, sometimes entrepreneurs or business people that are retired. So at those positions, we have to be able to argue how you're going to restart your career if we're going to go on the EB1 route. Nice thing about EB1 is we have premium processing. So it's a case you can put together, get premium processed in 15 days once it's approved. If you're in the United States on a non-immigrant visa, you can file the adjustment of status for green card. But if you're outside the US and maybe you have ESTA or a tourist visa and that wouldn't be appropriate to do an adjustment, then in those cases, you process the visa consular. As I've already mentioned, the consular processing right now is taking about 2 years once the I-140 is approved. That's the petition of the EB1 and the other EB categories. So that is a bit of a hurdle that we have to overcome, and we hope the Department of State gets a little better. So besides the EB1, extraordinary ability, we also have the EB1C, which is the multinational managers and executives. Similar to the L, this allows for multinational corporations that have a U.S. subsidiary or affiliate to transfer their executives or managers that have worked at least 1 year in the preceding 3 years for the foreign affiliate to come to take on an executive or managerial role in the U.S. To do the EB1C, the company must have been, that's the affiliate or a subsidiary, has to have been operational for at least 1 year before the applicant applies to the EB1C, and you can be an owner of the business and qualify for the EB1C. This is another avenue for people to self-petition a green card if they have, an operating business abroad, and then they have a real and operating business in the US that has been operational for at least 1 year, for which they want to come and work in a managerial or executive role. I will say that not all Ls, even though the criteria are very similar, USCIS has kind of a policy that they hold the EB1 to a higher standard because there is some discretion in this visa. We typically want to see some sort of track record of operations and a substantial workforce to really succeed on these EB1 cases. And that has nothing to do with how the criteria, the regulations are written. That's just a practice pointer that we've gained from experience. I haven't put it here, but there's also an EB1 category for extraordinary ability researchers and professors. Since we're talking more about self-starters here and entrepreneurs and investment, I'm not really covering that, but that's another category. And none of the EB1 categories require a labor certification. Now, EB2, this is our second preference category. This is for individuals that have an advanced degree, a master's or its equivalent, as well as individuals that can qualify as having exceptional ability. Exceptional ability means, a certain level of experience or expertise in the field that's above what is normal. And they ask you to document at least 3 criteria of the 6. Typically, they want to see at least 10 years of experience in the field, a degree or certificates in the field, evidence that you've had an important or leading role for the organization, for an organization of repute, and that you have a high level salary. So we can document exceptional ability by documenting at least 3 categories. Easier is the advanced degree. The advanced degree can be either a straight foreign degree or U.S. degree that is considered a master's or its equivalent, or you can combine education and experience. So if you have a university degree that is equivalent to a bachelor's, and after graduating at least 5 years of documented experience in the field, that is what we consider progressive, meaning you grew in your role, then you can qualify as an EB2 advanced degree professional. So the EB2 traditionally requires a labor certification. The labor certification process is when you go to the Department of Labor, you have to have an employer. And there's this whole process, it takes about a year that I'll talk about a little later, that has to be completed in order to apply for EB2. But we also have what's called a national interest waiver exception to the labor certification requirement. So for individuals that want to self-petition because they have the advanced degree or exceptional ability, and they can meet the criteria of exception from the labor certification by showing that they qualify for what's called a national interest waiver, then they can self-petition without going through the labor certification process and without having a sponsor. So in order to do this, you have to show that the work you're coming to do in the United States is of substantial merit and national importance. You don't have to show that you will work geographically across the country, but you do have to be able to demonstrate how the nature of the work will have an impact that is beyond the local geographic area or your direct employment, right? Typically, I find that with the EB2 national interest waiver cases, they don't much like you doing that case if you're an employee, because the idea is that this waiver is available to people that can't do a labor certification because it's not practical. So for consultants, people that need to be able to work in a variety of companies and not be limited to just one, or where getting labor certification sponsorship would be impossible or impractical for whatever reason. So you always have to show why, on top of the substantial merit and national importance, you should be getting this waiver because it's not possible for you to get the labor certification. The other element is you have to show that you're well positioned to do the work you're going to do, that you've already been recognized as being of national interest. So if you're saying, hey, I'm a biogeneticist and I am coming, I have all this recognition and I'm a consultant and I want to do my own business. You then have to also show that you've taken active steps to materialize this business so that you can prove that you're going to work in your field or that you have client job offers. So there's a little more to it than just being an advanced degree holder or being an exceptional ability individual who wants to come to the US and work. You have to be able to also show these other factors. Thankfully, we've gotten a lot more guidance on these visas from USCIS, and we are seeing a tremendous growth in this practice area, both for our business as immigration lawyers in our practice, but other practices as well. The approval rates have been, incrementally higher over the last year and a half. And we're seeing approvals for these, individuals who are working in all areas that right now are major concerns for labor shortage in the US. So anything that's science, technology, engineering, and mathematics related, the administration has already published guidance in USCIS policy that indicates that these are preferential fields and given us guidance on how to better document eligibility for national interest waivers in those fields. Labor shortages in aviation, hospitality, whether it's a cultural impact, there could be an economic impact because you're coming here and you're opening a factory or a business that's going to employ a lot of people. There's a lot of ways to present these cases. So if you're thinking about, migrating to the United States and you have a business idea or investment, it's well worth exploring this as another option. I found that the EB2 national interest waiver has been beneficial to my clients from countries like Venezuela and Nicaragua who are not intending to continue the operations of their businesses in those countries because of civil and political climate that make it impossible to do business. So they don't qualify for the L and the EB1 because they can't show that they're going to continue to operate as a multinational. So the EB2 now becomes a better option for those profiles. And so that's the EB2 with national interest waiver. You can also be an advanced degree professional or exceptional ability professional that has a job offer from a US company and do the labor certification process in EB2. And if you don't have an advanced degree, maybe you just have a bachelor's degree, or you have a technical degree such as an associate's, or you're a skilled worker with 2 years of experience, or unskilled workers, there's also the EB3 option, which again has to be sponsored by a US company. And in both the EB2 and the EB3 for employee roles that don't qualify for national interest waiver, they must do that labor certification process, which requires a year-long process with the Department of Labor. The company has to pay for recruitment, consider US workers that apply, and so long as none of the applicants are qualified or interested in taking the job, then they can proceed to file the application with the Department of Labor. You need to complete that 1-year process and get the labor certification approval before you can file the EB2 or EB3 I-140 in those cases. Once you get to the I-140 stage, there is premium processing. Unfortunately, on the EB2 national interest waiver, they're still holding off premium processing until cases have been pending 1 year. So the EB2 and EB3 with labor certification or the EB2 national interest waivers after a year can file premium processing on the I-140, get a response in 15 days. And then if you're in the US, you can do with a visa, you can do the adjustment. Or if you're outside the US or tourist or ESTA, you can do the consular processing, which, as we've said, takes about 2 years. EB2 and EB3 with labor certifications aren't really ideal for entrepreneurs, but there are cases where we have individuals who have come here on an E2 or an L. They're working and running their businesses, and their spouses have gone out and gotten a job at another company because they have work authorization. Now their spouses can get sponsored for a labor certification through their employer, and that would benefit the entire family group. So, you got to kind of think about these things in the context of the whole family picture, not one just, unifocus. There is an EB4 category for religious workers, but that doesn't really apply here. So we'll go to the EB5. So right now, the EB5 program with regional centers has been reintroduced. I can't remember 900,000 or 800. We're talking about the number, but with the regional centers and an investment above 800,000, you can file for an I-526. A regional center is a program that has been certified by USCIS to accept almost like hedge fund type investments from qualified investors. The money that you invest in a regional center is at risk, right? So you're putting it in an investment program. The regional center will have to demonstrate at the end of the project that they have been able to create and maintain as a direct result of your investment 10 jobs, but they don't have to be direct, right? So they can do indirect jobs, which allows them to do this with sort of economic models. The regional center model has been the preferred EB5 program. There was some questions about whether it was going to be able to advance because there were some changes in the law in February that made it very hard for current regional centers to comply. But thanks to a lawsuit by our good friend and colleague, Ron Klasko, it seems that they're now able to resume regional center funding like it was before. The amount of the threshold is higher. And the nice thing about regional centers is that you can do the lower amount. If you want to invest in your own business and it's not in what's considered a targeted employment area, then the investment has to be 1.8 million. And it's a direct investment, meaning you're putting your money in whole and you have to create 10 direct jobs. So you have to show 10 employees. The really cool thing about the new law on EB5 is that now you can file your I-45 adjustment with the I-526. So you're going to be able to file for your temporary green card and get your work authorization and travel documents concurrent with your initial investment. This was a problem before because they wouldn't allow you to file the I-485 until the I-526 was approved. But because it was taking so long, in some cases 3 to 5 years, for the I-526 to get adjudicated, people were waiting for 5 or more years, especially if they were outside the US, to be able to come to the United States after having invested this money. That is now not the case. When you're ready to make the investment, if you're here in the United States on a valid visa, whatever visa that is, you can file for the I-526 and adjustment of status of your family group at the same time. And that will allow you to live and work in the United States while that process is pending. Now, on the EB-5, there are 2 phases. First, have the I-526. Once that's approved, there's a 2-year wait period. And then after the 2-year wait period is, you can file the I-829 for removal of conditions. So the thing there is you're not going to get your permanent green card approved until the removal of conditions is approved. Based on current processing times, the window timeline from I-526 filing to I-829 approval can be 8 to 12 years. So it takes a long time and you can't get your money back until the I-829 is approved. And that's if there's money to give back, because as we all know, the regional centers, depending on how they're structured, the money has to be at risk, so they can't give you a guaranteed return on investment and your capital.